It's a scam. It's a scam. That's not a trial. That's not a trial. That's a scam. And what they're doing is a crime. They are criminals. All I can do is tell the truth. And the truth is that there's no case. They have no case.
So that's item one. He claims he would testify, but would and will are two different things, and it remains to be seen if he actually will sit down on the stand under oath. Item two is what the judge today ruled on another delay attempt, plus a new request about jury selection. For that, we go to Kara Scannell. So, Kara, can you just talk about this last-minute filing from the Trump team?
So there was a new decision tonight by Judge Juan Merchan, who's overseeing the case, saying that he was denying Trump's motion for pretrial publicity. Trump was saying that because of all the publicity, he couldn't get a fair trial in New York. Judge denied that, saying that Trump, in fact, has caused a lot of the pretrial publicity, saying
the courtroom air feels like a pressure chamber, thick with the weight of a country watching history twist into something unfamiliar. And as Trump stands in front of cameras insisting it's all a scam, swearing he'll testify, swearing there's no case, the disconnect between his confidence and the legal reality tightening around him becomes impossible to ignore. Because everyone who has tracked his behavior over the years understands that saying he would testify is not at all the same as actually taking an oath and answering questions he can't twist, dodge, or shout away. For years, he's weaponized the slow machinery of the legal system by filing delay after delay, motion after motion, appeal after appeal, until every deadline becomes a suggestion and every trial date turns into a moving target. But that game is finally collapsing under its own repetition. The latest blow comes from Judge Juan Merchan, who dismisses Trump's argument about unfair pretrial publicity, pointing out the obvious truth that Trump himself fuels much of the chaos he now claims he can't escape. His legal team responds with the same playbook they always use. Complain about venue bias, cry foul about jury selection, claim prejudice, demand fairness, while pulling every trick available to avoid being judged by anyone at all. Legal analysts on television dissect it in real time, explaining how he's not preparing for the trial in front of him, but for the appeal he'd file after a conviction he increasingly knows is a realistic possibility. They point out how he wants jury data preserved so he can spin it into a narrative of injustice later. They break down how every new filing is less about winning in the moment and more about building the illusion that the process itself is corrupt. But in the halls of the courts, the mood has shifted. Judges aren't indulging the theatrics anymore. They're not pausing schedules to negotiate with an endless carousel of emergency motions. They're issuing decisions quickly, firmly, and without the hesitation that once defined Trump's interactions with the legal system. The hush money case became the clearest example of this new attitude. His lawyers claimed media bias, political bias, timing bias, anything and everything that might convince a judge to push the trial a few more months down the road, maybe even past an election. But an appeals judge shot down the emergency request with blunt efficiency. No delay, no reconsideration, no bending. The trial proceeded. Then came the second attempt, another last-minute motion, another desperate push for pause. And that one was crushed almost instantly as well, dismissed in an emergency hearing that resolved the issue before the news cycle even had time to inflate the drama. His team kept filing, kept pushing, kept throwing procedural spaghetti at the wall, but the tactic that once extended cases months or years now barely buys him an afternoon. And when the guilty verdict came, everything escalated. The old strategy kicked in again. Delay the sentencing, challenge the conviction, claim the court made errors, insist the timeline is unfair. But the appeals court rejected those requests too, refusing to postpone sentencing even after Trump's lawyers tried invoking every creative interpretation of justice they could muster. Judge Merchan's order stood solid. Trump would appear in person for sentencing. No privilege, no exemptions, no presidential aura to soften the rules. This is the moment he's been trying to avoid for years, because once he takes that witness chair or stands before a sentencing judge, the risks multiply. If he tells the truth, he could destroy his political future. If he lies, he opens the door to perjury charges. If he pleads the fifth, years of his own rhetoric about only guilty people, taking the fifth comes back to crush him politically. There is no outcome that helps him, only outcomes that hurt him in different ways. And judges across the country have stopped buying the argument that presidential duties or executive privilege should shield him from the consequences every ordinary defendant faces. Federal judges in Washington have already begun rejecting his immunity claims, refusing to accept the idea that former presidents should be exempt from testifying like anyone else. The logic is simple but powerful. The rule of law applies to all, not to most. And as this principle tightens its grip on his legal reality, Trump's options shrink faster than his lawyers can draft new filings. What makes this moment historic isn't just the looming threat of more testimony or more trials. It's the sudden, seismic shift in how the legal system treats him. For nearly a decade, he operated as if the courts were just another stage, another arena where performance mattered more than procedure. If things got too tense, he'd delay. If they got too close, he'd appeal. If someone pushed back, he'd drown the process in paperwork until everything slowed down enough for him to regroup. But that spell is broken. Judges aren't dazzled. Prosecutors aren't intimidated. Appeals courts aren't indulging hypothetical emergencies. His delay tactics, once his strongest weapon, have become predictable, obvious, and ineffective. And with every denied motion and every rejected delay, the moment he's been running from draws nearer, the moment where the oath becomes unavoidable, where improvisation becomes impossible, where even a lifetime of dodging accountability can't save him from the simple truth that the law doesn't care about slogans, rallies, or polls. It cares about answers.